I'm Romain P. I run the investment team for AIM, which stands for African Infrastructure Investment Managers. We are an African-based investor specialized in investing into infrastructure across the continent, only in Africa. We got $1.9 billion under management across 6 funds, and we see ourselves more as a forced developer. We'll come back on that, rather than necessarily a true developer. We have together with us this afternoon a very experienced panel, mixing bankers and lawyers, and I think it will allow people to give, we hope, a more balanced perspective to the debate. And coming to that, what we were asked to, in a way, address is what are the typical mistakes which have been made by project developers when negotiating agreements? And I think maybe the first one is make sure you cap your legal counsel fees, but we will come back on that. So I think we have 2 charts, so we'll ask first each of the panelists to give a quick introduction and maybe just to share some experience, starting with in the middle by Charles Morrison on that, and then we'll sweep to the left, and then we'll come back on the right. Yep.
Oh, press 1, yeah. My name is Charles Morrison. I'm a project finance project partner at DLA Piper, based in the London office, but I spend a great deal of my time working on projects in Africa. I'm also called to the Tanzanian bar, where I spend a fair bit of time working. And if I say that I've been working presently for the lenders on the IPTL power project in Tanzania since 1999, I'm probably the last person to be talking about mistakes in projects and how to get them developed quickly. But I can give some perspective, I hope, which comes from, as I say, many years, 20 years plus working on projects in Africa and elsewhere in the world. I think the starting tip is that if you have as your basic principle aiming at a project that everyone involved in it can be proud of, you won't go far wrong. So if you think about it from the perspective of the utility or the government, that the utility can stand up and feel it's a PPA to be proud of, not one where they have accepted a range of points that they really ought not to have and are embarrassed about, that the government could stand up and defend in its parliament, that the lenders will feel content with, and that you feel that you've had as a developer a reasonable equity return built in, you won't be going far wrong. The other tip I'd give from the start is, and I heard this coming out from a number of the contributions over lunch, having an experienced team, the right team, that can just help in so many different ways. So much of the time that's wasted and the cost that's built up is as a result of not having the right experience on the teams. And I thought that one of the contributors made a very important point, that governments need to have that expertise as well on their side, and there are, as was pointed out, a number of funds that will pay for that expertise, or the project itself can pay for that expertise and the cost can just fall into the model, and is de minimis over the length of a project, but can actually help get the project done. So what's the overarching point there? It's understanding the legitimate interests of the players in the project. If you can start from that standpoint too, understanding what is the legitimate interest of a host government. What's the legitimate interest here of the banks looking to lend? And then what are the legitimate interests of me as equity if I'm developing it? If you can have a clear idea of those points, then again, you won't go far wrong in developing your project, and you'll avoid a number of the mistakes that are commonly made. So a few tips then in my 5-minute contribution. If you're the developer, start off with solid shareholder arrangements, get your shareholder arrangements documented properly in a solid shareholder agreement that addresses governance and the roles of the parties and a clear dividend policy. Having a clear view on your model from the beginning, the right advice on your model, knowing what your model's going to do, the right debt equity split, and knowing, again, thinking about your interests, the legitimate interests of lenders on the debt. Just think about how you're going to position your negotiations, and each side will have different views there, but that's something to get straight from the beginning. Then moving on to the project documents, concession, ask yourself, do you need a concession? Is that actually needed for your project to develop it? And what other form of document would suffice, or rights do you need? But if you do end up with a concession, then making sure that that's properly negotiated, of course. Look at the governing law on the forum. A point was made about arbitration and the importance of that. Just think about the balance of the availability of arbitration, because it can be fiercely expensive. You think project finance lawyers are expensive, just wait till you deal with arbitration lawyers and litigation lawyers. And just think about who has the right position in any arbitration, because given the cost, given the delay, governments are often emasculated when they agree to a foreign arbitration. Do you want to try and have an arbitration with a seat in Johannesburg or Nairobi or somewhere rather than London? Think about whose interests you're working to there, but very, very important point.
Charles, maybe we need to leave also the other lawyers to have walking down through the list of documents. We'll come back on you. I think you mentioned a couple of interesting points. Maybe if we'll just let Kieran just...
Very happy to. Thank you. Yes.
Good afternoon, everybody. My name is Kieran White. I'm a partner at Baker McKenzie Johannesburg office, and I've been quite involved in the renewable energy program as well as the coal-based load program going forward. I fully endorse everything that Charles has said. I would just like to add a couple of things. Is hopefully the procurement program that you get involved in, first of all, that there's the political will to see the program through, and that there's a champion in order to do that. And I think in the REAP program, we were fortunate with the IPP office in the form of Corinne Breitenbach that we did have that. The other thing I think what we hope that we will find is that there's utility support for the procurement program. And obviously in the South African context, that was Eskom. Is it fully behind the program, or does it have its own reservations? And what's the tension like between the utility and the DOE, which was the procuring agency? I think is, in all these projects, you have to understand that it's a jigsaw puzzle. And if you get one piece of the puzzle wrong, you're not going to finish the jigsaw, and it's not going to happen. And at the end of the day, it's also going to be all about project finance and the bankability issues. And if all the counterparties in the transaction don't understand the fundamentals of project finance, we're going to have a long and protracted discussion on various documents. We need to also appreciate the procurement program and how rigid is it, and how is there integrity to that procurement program. Because at the end, as soon as you bring in the international side, you bring in all the compliance issues that go with that. And if the compliance issues can't tick the box, there's not going to be any lending coming into South Africa from elsewhere. You need to also understand the regulatory framework of the project that you are operating under. And you have to fully understand it and all the policies as well. In our case, under the renewable program, you needed to know what was going on, because if there was a change, you wouldn't get any relief. So it's all coming down, and I think, Charles, you touched on it, it's all about cost and time. And if you don't get the right team and you don't have a fully integrated advisory team, there's going to be problems on time, and that's going to equate itself into costs. I think you also need to appreciate what's the financing plan for the developer. What are they doing? And what's the financial model? The financial model becomes very important, because that's what the shareholders look at, and that's what the bankers are going to look at. And for every thing you give up in a negotiation, or thinking of giving up in a negotiation, you need to understand what's the impact on the financial model, if any. So you need to appreciate the risk appetite. You need to do a risk analysis. You need to understand your fundamental documents. And then I think you don't need to reinvent the wheel. If there's standard documentation that works, keep to it. If it doesn't work, then change that which needs to be changed. We had experiences, we got to round 3.5 of the renewable program, and all of a sudden people wanted to start changing all the legal opinions that had been given previously. And when you showed counterparties, but this is the opinion you accepted last time, they wouldn't accept it this time. And that could also be true across the board on it. So there's a value chain that you need to understand, where it's all coming from, how it flows down to the EPC and the O&M. There's some opening remarks.
Thank you, Kieran. You mentioned something which I think Teuss was very keen when we were discussing in the meeting room, integrity of the procurement process. Teuss, if you want to.
Thanks. My name is Tiens Illes. I head up the project finance team at ABSA. It's quite impressive to have a lawyer sitting next to me talking about financial models. So, Kieran, that's that's great. It's normally something that the banks and the financial advisors and the sponsors worry about. But just going back to that point about, I'm just going to raise 3 points and then maybe we can deal with some other issues. The first issue on this procurement process, maybe not so much the case in South Africa, but if you go outside of South Africa, sponsors can and developers can secure deals in many different ways. But one of the first things from a lender's perspective and from a bank perspective we typically ask is how they actually secured the contract. Was there a proper competitive tendering process, or was it a bilaterally just one-on-one agreement? And typically, and lots of governments can procure in many different ways, and that's perfectly fine. But in the second scenario, where there wasn't a proper competitive process, we will also then go and actually have a look at how affordable and reasonable the tariffs are that's actually been negotiated. The chairman mentioned that you actually need a good deal for all parties, including, Charles mentioned. And that's so true. I mean, if you sit with a tariff potentially that's unaffordable, it may generate the best equity returns that you've ever seen. But actually you're exposing yourself to a lot of risk down the line of government potentially trying to pull out of that contract. So procurement-wise, that is quite important for us. And I think that's one of the reasons why the South African program has been so successful through the various rounds, because it was creating proper competitive tension from a tariff perspective, and obviously from a bank's perspective, we all sort of competing for the same pot. The second issue, and again, this is not really in South Africa, outside of SA, which is really becoming quite a difficult issue for us to deal with. It's this whole issue about currency risk. Now, you can imagine if you sign a power purchase agreement, or even if you do a normal concession contract in Africa in dollars, and you sit in a country like Zambia where almost overnight, the currency depreciates by 30–40%, you're in a very difficult space. And increasingly now, and it's always been the case, we need to find solutions for these things. Now, in some cases, and I think this is probably one of the reasons contributing to so many deals just getting delayed endlessly, but you've got to find other ways to try to mitigate this currency risk. Now, there's no, I can't sell you a secret solution that's just going to solve all of these things. But contractually, from a lenders and from a sponsor perspective, you've got to make sure that you're not the one actually finally exposed to the risk. So you're obviously going to try to mitigate the risk by putting as much as possible on the host government to underpin certain payments. And in some cases, if you speak to lenders about, and this is coming on to my third point, one of the biggest challenges that we have in Africa is the credit quality of some of these utilities. Even our own electricity utility, Eskom, is also facing enormous financial stress. So as a start, you would like the host government to back up their commitments through guarantees, through letters of support. I'm sure the lawyers will have many different sort of structures to achieve that level of support. But in some cases, even that host government support may not be sufficient, in which case you need to look further to get the credit wrapped by an external party. And that's when you start looking at the likes of the World Bank. MIGA's got products, and even there's some private insurance products. So just to conclude my part, and again I fully agree with my with the speakers before me. Try to involve not only the lawyers and not only the advisors. Try to involve your banks as early as possible in the process. so that we can help you navigate through some of these key bankability issues and sit alongside you trying to find solutions to get these things done. Because the last thing we want as a bank is for someone to show us, but we've got our PPA, it's fully negotiated. We've got our EPC contract. There's our direct agreement as well. Now just give us the money. 9 out of 10 cases, that's just not going to work. So we'd rather sit alongside you from the start and make sure that we negotiate these documents, we actually sign something that's bankable. Thanks.
Thank you. And I think that's something which I felt has not been discussed to date. What we're saying in different words is the whole supply chain on most of the power sectors is not sustainable. What we're saying is there is an economic player which is making massive amount of losses, usually the national utility, and that's required, in fact, heavy structuring and a lot of parties involved to try to fix it. But Charles, if you want just to add your contribution on what you think is hindering project development in Africa.
Thank you. Good afternoon, everyone. My name is Charles Murray. I head up the Projects and Energy team at Hogan Lovells in Sandton. One of my biggest challenges over the years is trying to convince engineers that there's no such thing as a one-pager. That is really a debate worth having sometime. But I have a couple of basic, rather gloomy opinions about doing projects and project finance in particular. And that is that very often there's an underestimation of the time, the cost, and the complexity of negotiations. And I always believe that it takes longer than you think, it's more difficult than you think, and it's going to cost more than you think. So beware the aggressive timetable. Very often we get confronted with timetables. We want to start today, we want to close in winter. I had this in a neighboring state recently. There was a gas to power project, very, very urgent. We needed to close this thing within 6 months. But of course, there are very, very long decision-making processes on the other side of the table. Understand the legal environment in which you're operating. When first doing business in a country, procure a country report so you can understand how the finance system works, how the banking system works, how the legal system works, how land issues are registered, how they're regulated, how you go about setting up companies, joint ventures, and so forth. We had a client very recently who came to the country very aggressively to do a PV project, and within 2 months it left because they just couldn't come to grips with the land issues. They were concerned that there might be fraud, and what was the recourse to the seller if he sold the land twice. And that really just adds a lot of frustration and cost to the whole process. And as my colleagues have said already, appoint advisors early in the process. There are generally 3 primary advisors in a project financing. That's technical, commercial, or financial and legal. And I believe one can divide the project more or less into 3 distinct phases. First of all, there's the pre-feasibility, which is probably largely technical and to a certain extent commercial. Then there's the bankability and the credit phase, where legal, commercial, and technical probably play equal roles. And then you have the documentation phase and financial close, which is to a large extent legal, as all the term sheets are being converted into legal documentation. But it's always a good idea to get lawyers involved as early as possible, and lenders as well, because it's very, very difficult and takes a lot of time and is costly to reopen negotiations or to go back and restart negotiations to address lender requirements. So that you want to avoid these delays, because delays ultimately are very, very expensive. The other thing is, don't underestimate the opposition. Counterparties are well advised, so send in the A team. It's always a very good idea to have decision makers at the table, and that is usually beneficial in the negotiating process. And here's something that I feel quite strongly about, is one always tends to assume that the lenders are being unreasonable and taking advantage of what you might perceive as being a buyer's market. That may be so when it comes to margins and fees, but seldom when it comes to covenants. Lenders, after all, are dealing with other people's monies, and they have to make sure that that cash is repaid, beyond a reasonable doubt. So I think one has to assume that the lenders are not being deliberately difficult when it comes to lending covenants, but that is not to say that you shouldn't bargain hard. But understand that you must understand the credit issues. Another thing is flexibility when it comes to returns. very often return expectations are rigid, which means that it's difficult for the negotiators to go ahead and agree to certain changes to stricter covenants in documents like the EPC contract. So there should be some elasticity built into the return expectations. But if you cannot overcome this problem, then the challenge is to exit as neatly and as quickly as possible. And we've touched on a couple of the other things. Make sure before you embark on a project that the infrastructure is in place, or if it's not in place, that it's in the program. We've touched on the need for a strong shareholder base, a very well-constructed shareholders agreement. Understanding the rules of engagement. One of the reasons I believe that the REAP program in South Africa has been so successful is because the rules of engagement have been very clear. And of course, poor documentation is always a large problem. So make sure that documentation is up to scratch. I think we mentioned a little earlier, documentation is to a large extent becoming standardized, and that should help the process going forward. And I'll conclude there.
Thank you, Charles. Thiago, you were telling us of the record about a project where you've seen quite late, quite unbankable sovereign guarantee. So on a no-name basis, maybe you can share a few of the stories.
Thanks, Roma. So my name is Thiago Almeida. I'm with the Rand Merchant Bank in the infrastructure finance team, and been involved in sub-Saharan Africa transactions. So I have some experience in REAP. I will not bore all of you with that. So as Roman suggested, I think most of the key points have been covered. So I'll probably focus on some interesting examples that I've experienced and maybe lessons learned for all of us. So I guess speaking on the point already mentioned around involve your bankers early on. I think that's really fundamental. And again, because we had a situation, for example, where the sponsor, a very important sponsor, actually very plugged into that particular country, which had some of the most important documents for us already signed, and one of them being the guarantee that the government need to provide to the lenders for any sort of early termination event. And basically, when we started to look at that project, and we had a 2-page guarantee from government. And obviously, when we started to look at that, there was so many gaps and holes in that document that for more than a year, I think, we actually just been sort of discussing with the lenders' advisors and the sponsors' advisors on how to amend the guarantee. So that was one of the problems. And then the second problem was actually to convince the government to accept our changes. Because as you can imagine, you can't just go to government or parliament and just, please, now you're going to sign another one to replace the previous one. So please, I think, the lesson there was really have your advisors or your bankers engage early on in the process, particularly when it's more customized sort of projects, which you see in sub-Saharan Africa more than, for example, in South Africa, where there's a lot of templates for most of the documents. So that is actually fundamental. Then the other thing that I think is quite important, and again, building on a sort of an interesting example that we faced, is I think in some governments in Africa, just again, try to build a partnership relationship with your utility or the government on the other side, because sometimes, and it happened in one situation, you have government signing something which probably they actually didn't quite understand what they were signing up to. So that created an expectation from the sponsors and lenders that, we are protected if X, Y, and Z happens. Well, imagine what? There was a problem, and it was because a situation where the government, one of the government stakeholders had a specific obligation to deliver a piece of equipment to that particular project, but guess what? They actually didn't realize it, or they just came to their radar very, very late in the process. So that ended up having a project which basically was, almost completed, but could not operate. And I think that the lesson learned there was that clearly, there was some naivety from the part of the sponsors saying, well, no, we are protected because contractually there's early payments and, deemed availabilities and all of that. But interestingly, it was, quite obvious to most of the people in the room that it will be actually, somewhat a problem for that particular utility to come up with those payments, where no electrons were being available. So again, just make sure that the contracts are the contracts. What's in the contract is meant to be complied with, but from an expectations point of view and understanding of actual arrangement, just make sure that you as sponsors and the government on the other side are actually aligned in that regard, because again, that can lead to, which in this case is sort of the case, a restructuring of the whole project effectively. You know, so that's equity risk fundamentally that is being taken, and you know, protect yourselves against those situations. Then I think from you know, I think most of the key points for me again have been mentioned. There's not a lack of liquidity for good projects. I think, you know, we banks, we're really looking around us probably as hard as you to find good bankable projects. So you know, there is money out there. The issue really is to, you know, make sure that those projects are bankable. And then risk allocation issues, you know, your typical force majeures, etc., government support, make sure that, you know, if there is a collapse of the structure, you know, the lenders are protected through government compensations and then backed by MEGAs or etc., whatever it's required. And making sure that all of that is perfectly understood by all the stakeholders. Without that, there's no project. Without a good PPA, there's no project. There's no point in spending time on anything else. Then just a general advice, I think, from a lender's perspective, you know, we often see sometimes some of our clients or sponsors, you know, looking at us more sort of on an arm's length basis, and that really should not be the case. I think someone already mentioned here, you know, we all need to be proud of the project at the end of the day. So really try to build a partner relationship with your bank, with your bankers. I don't think we should focus too much on margin. If the margin is 450 or 455, you know, at the end of the day, I think it's the probability of getting to financial close, and also your, as sponsors and developers, your equity return. So even if the margin from that particular tranche may look high, you know, maybe that bank has other solutions from a structuring point of view, other type of, you know, debt facilities that can actually then improve your returns. So focus rather on that than debating the margin. I will leave at that.
Thiago, I think you mentioned something which is very close to my heart in that sense. You know, I think it's a partnership between the public sectors and the private sectors. And it's very important both sides stand at the table perfectly understand what they're committing to. You know, if I would just copy what Charles Morrison was saying, it needs to be a good deal for everyone. And one of the questions I have for you, Charles, is, you know, for being a good deal for everyone, it is very important that the public sector, the government, is being well advised. As you say, there is plenty of facility, African legal support facility, European Union, a lot of capital available for government to hire a proper advisor. Why are the government not tapping these facilities more often? Why are they still going with the local legal counsel instead of having a very experienced team along their side?
It's a very good question, Rowan, very good question. I think my experience is that the system within many African governments, and I act for some of them, is to just naturally go through the Attorney General's chambers. There is an expectation of working through the AG's chambers. Their own, in the ministry, their own legal team will just, the way the system works, will take them to the Attorney General's chambers, and the Attorney General's team, the state attorneys, will attempt to negotiate the deal. When it's pointed out to them and they realise that there are these funds available, or indeed that the project can pay, and I worked on one in the early 2000s where the government of Ghana I was for the sponsors, but the government of Ghana quite properly demanded that their engineering advice, which they needed and which helped the project to be agreed much more smoothly and quickly because they had experienced engineers on their side, the cost of those engineers was subsumed within the project cost and was added to the model which the sponsors had to develop and cover with the tariff. So governments can do it, they do it, they don't do it enough, and I think the reason is the system expects them to work with the Attorney General's chambers. They are given the cover, as it were, from the stakeholders within the government machine if they are seen to be working with the Attorney General's chambers, and I think it's just a question of educating AG's chambers to the fact that there are these support facilities available. I think a speaker at lunchtime made the point about PPP units, which develop expertise within them, the legal expertise, the commercial expertise for negotiating concessions that can make things very much smoother. I think that would also help.
Okay. Kieran, just a question for you. Do standard form documentation or documents help or hinder project development? So are you recommending more IFC scaling solar, or do you think it will only be part of very limited part of project?
So I think when it comes down to the financing side, is obviously there is a set of precedents out there that everyone is very familiar with, the LMA standard. There's going to be various issues you want to discuss and negotiate. So certainly that should be able to cut down time. And I think what you need to focus in on those issues that are not acceptable to you instead of negotiating the whole document. So sweat the big stuff. Don't get into the minutiae, because that can be sorted out between lawyers instead of a room of 35 people spending a whole day and you only get through one clause, and that's sometimes a definition. So certainly there is a lot of merit to that. There's also in the EPC and the O&M world, particularly the EPC, there's a suite of standard documents out there. So you need to evaluate, are those going to be project specific and can we use them, or should we have a bespoke agreement or not? So I think in the REAP program, sometimes it was easier to use a bespoke agreement as opposed to using all the FIDIC agreements where you would have had special conditions outweigh the general conditions with all the changes that needed to happen. I think the other thing that where standard documents can help is prior to the REAP program, there wasn't really that much infrastructure built in South Africa that was being built through project finance other than the concession, the roads. The rest was being built by Transnet and Eskom, and they were using their own standard agreements. They weren't using industry-specific ones at all. So there's an example for us, and say, I think you need to ask yourself the question, what's going to get the job done? And which is the right one to do? I think the other thing when it comes onto this, and it touches a little bit, Romain, I'm going slightly outside of your question, is I think it's also about your capacity of the people that you use. Because there is no reason why you cannot run certain negotiations of key issues in parallel, as opposed to, in some instances, in my experience, sorry, we can't meet for the next 2 weeks on the EPC, the O&M, or a fuel supply because we are doing finance agreements. So everything just stops until the finance agreements are finished. And then there's no interlink and interplay, and I think, Charles, you touched on this as well, is this interdependency of all these agreements. And there needs to be communication between the various teams that are negotiating. I don't think there can be enough communication between the teams. And I think there also needs to be a measure of collegiality. Sometimes pick up the phone and talk to your colleague on the other side. You don't need to send an email, copy the whole world, because then your colleague sits there and say, what is the message that they're trying to get to me? So then he or she returns that and copies the whole world again. And then the other 25 people all say, what did they mean by this? And now we've got a whole lot of parallel communication going on, which is totally irrelevant to the issue on the table.
Charles, Murray, do you want to add something to Kieran's?
Sorry?
Do you want to add something to on standardization of project documents? Or
Yes, I believe that the process can be streamlined. I'm not too sure that one can come up with a perfect template for every type of document, but I think we agree that probably 90% of the content of these documents is pretty well understood in the market, and it's up to the lawyers to refine the other 10%. And the other thing is, very often, I think perhaps what we do as a profession is try and get too involved in the commercial issues, rather than just documenting what has been agreed between the counterparties. So I think that there probably is scope for more efficient drafting, and I agree with Kieran 100% that, you know, as colleagues in the profession, we should be having more and perhaps more frank discussions with each other offline, just to make sure that there are certain issues that are not going to bog down the process entirely. So I think that that's one way to perhaps looking at getting sure that costs are kept in check, that timetables are adhered to, is perhaps a little bit more give and take in the process. Lawyers can be very stubborn, and of course there's a lot of ego sometimes on the table as well, and I think we can do without that. But I like to think that at our level, Kieran, we're way past that.
Thank you. One of the very sensitive issues which was raised this morning is clearly developers want to be rewarded for the risk they're taking. And there was a discussion on development fees this morning, saying some of the mighty banks and DFIs are not necessarily accepting to recognize the full development fees. Thiago or Tius, if you want to say what's your views on that? Is there a magic number, being percentage of project cost or others, which you need to get to?
So you're throwing me this curveball now. This is not something we discussed before. Look, I think all the banks have different views when it comes to these development fees. Obviously, it has to be reasonable. No one will look at something and just accept something which is totally not in line with market. But I think more importantly for us, when we look at these things, is the numbers still have to work. So if you look at the South African Renewable Program, for example, if you put an extraordinary massive amount of development fees in these models, clearly the end resulting tariff is no longer going to be competitive. So ultimately, you've got to weigh up the balance between these different things. So as a firm, our view, we don't have a cap on these things. We're not going to impose specific rules, but we do want to still see them overall to be reasonable, and the numbers will have to work.
Thiago?
Yeah, I think I
Just
would.
for the audience, Thiago will show me a number 5. So I don't know if it's 5% or 5 million.
5 minutes. No, I would agree with Tony. I don't think there's a number. I think it's quite project specific. Obviously, in the RE-program, it's sort of, balance itself out, to make the project competitive. In a situation there's not a bidding process, competitive tension going on, I guess, we would sort of benchmark that against similar projects that we've done in the past. And ultimately, as a mighty bank, as you suggested, we usually don't like the fee to be completely taken out at financial close, because then there's really no real equity from the sponsor, from that point onward. So usually we would follow what our credit committee would ask for, and sometimes we can go through sort of a partial payment of that fee at financial close, and then delay the rest to once it reaches COD, in order to actually make sure that everyone has an aligned interest in that regard.
Thank you. I don't know if there is any question from the audience. Can we have a microphone? You may want to stand up and try to shout.
Here's the microphone. My name is Abna Mangokwane from Lebona Engineering. I'm just quite curious to find out, from the willingness from all parties in this room, in terms of, do we need to have maybe a new common different language, because we've got all these contractual documents that we as service providers often have to purchase. Are these documents talking to us, the technical people who've got maybe the technical or engineering solutions, together with the funders who've got the figures behind them, and the bankers that need us to make sense, in terms of going through with these projects, and also the legalistic people to come in to make sure that the technical solutions are viable, the legal people understand what you're trying to implement, and the financiers also understand how we want to do certain things. Do we need a new language around that? I guess that's just a...
Maybe, I think it was Kieran or Charles. I think what we're saying is your developer should be able to integrate the different dimension of your projects. I transform the financial model into what the legal position is, into what the technical position is, into that. So some people have mentioned as a commercial or financial advisor. Sometimes your developer is having the skills to bring that together. And I think he's acting very much as a translator into that. Charles, you want to add something, or Kieran? No.
Yes, I think that the important thing to remember is that the legal input is really in the documentation. And the documentation, to a certain extent or to a great extent, is simply verbalizing what is agreed during the negotiations. And the basis of those documentations is the term sheet. Now, the term sheet is not drawn up by a bunch of lawyers. The term sheet comprises everybody who's got a stake in the project, technical, financial, insurance, whatever it might be. So I think that what the lawyers do is they use well-understood language which has been developed over a long time, and insert clauses which have probably been tested in a court of law to make sure that they actually do what they're intended to do. So I think that, and Kieran alluded to the fact that there is a lot of commonality in these documents already. You look at one EPC contract compared to another, you'll find that there's a 90% overlap to a large extent in those documents. But what the lawyers do is we don't actually create the projects, we don't actually determine what the technical solutions, what the financial solutions are. We merely assist in the negotiation process, and then we convert those term sheets into definitive documents.
Okay. Do we have time for closing comments? Yep. Tius, we'll start by you. A few things.
Yeah, thanks. So not much more to add. So I think the bottom line from a lender's perspective, and I agree with my colleague from RMB, not about the margin issue, that I agree with as well. I don't think there's a lack of capital in the market, both equity and certainly not debt. But I do think there's really still a lack of good bankable projects. So for those good projects, you know, you will definitely find the money. And what we're also really struggling with, and I'm sure a lot of you are struggling with all over Africa, it's just the speed at which things get done. And I think that's why it's good to discuss, you know, things like standardized type documentation to move things along. We've looked, for example, at the IFC Scaling Solid program. Absolutely great initiatives, because you are taking a lot of the key risk out of these deals up front. But we need to roll those type of things out all across the continent. Because, you know, like you guys, I mean, we don't get paid if we don't close deals. So I'll just leave you with that. I don't think there's a shortage of money when it comes to good projects.
Kieran?
I think as we go through these projects, I think there just needs to be a fair amount of mutual respect to each other and to all the disciplines that interact in these projects. I think we need to understand that which is negotiable for a party and that which isn't negotiable. And those that aren't negotiable, if we understand the rationale behind that, collectively we could perhaps come to a solution. But it's no use going down a cul-de-sac and flogging a dead horse if somebody can't move from a position. And rather just park it, take it offline, enter into some bilateral. But before we do that, make sure we understand why the person, our colleague on the other side of the table, is saying no.
Charles?
Yes, just to pick up the point from my colleague on the left, I think that the standardization of documents has really taken project development forward, and the World Bank IFC program to roll out standard form PPAs, for example, in the energy world has been, I think, a really important development, so that governments or utilities start off with a decent form PPA and get the negotiations off on that footing. The Loan Market Association has done its job on loan agreements. The days of lawyers putting forward their own loan agreement and negotiating it are long gone. Everybody knows what a loan agreement should look like now. They know the points to take and the points you shouldn't take. If you have experienced advisors, it's not the documentation that will be the problem. It's just focusing on those usual commercial risk points, the force majeure, the change in law compensation, the liquidity protection for your tariff, your debt service reserve. Those kind of issues are where the time is taken in a project. It's not in the legal documentation per se, but to see more of that standardization, absolutely. And as I say, I applaud the efforts of the IFC and the World Bank in rolling out those programs around Africa.
Charles Murray?
I think at the end of the day, the negotiating parties must go away thinking they could have done a little bit better, but are still satisfied that they've closed the deal. I think it's so important to close these deals. The country needs the power or the infrastructure that is on offer. And I think that with the right amount of goodwill, the right amount of intention, and the right amount of patience, that these projects should close. I think the bidding process is a good one because you are going to end up with a price which is probably best for the country. So I think that with the right attitude, the right will, and the right determination and energy, we will get these things closed.
Thiago?
I think just sort of a final comment, and again, lesson learned. I think South Africa is a very different market from the rest of Africa, and even within the rest of Africa, you have very different markets. Some are more matured than others. So I guess my sort of personal advice would be, particularly for developers going out there, that you need to also recognize the other side. So you know, some of them don't have the same level of sophistication, of experience, of skills, and sort of be to some extent aware to that, because sometimes we see some frustration on the other side because those entities feel that, you know, this is sort of the international developer with its foreign banker coming in and trying to just impose something on us. So just, you know, be a bit attuned to that. And under the same sort of theme, I think something that hasn't been mentioned here, and again more valid to markets outside of South Africa, which are not necessarily that sophisticated, is even in terms of the laws of those countries, sometimes it's not even clear. You know, if you go and start, we had this discussion around, does the project require tender or no tender? I mean, we had 3 legal opinions, each of them with a different view on the same issue. So I guess it's really fundamental as well that when you embark on this journey, you identify, you know, if possible, a good local partner that can help you sort of to navigate those issues. Fundamental, and I think it's very often overlooked, it's actually a good local counsel. I mean, in some of these markets it's actually very difficult. I mean, more than once we had on one specific issue asked different lawyers in country, and we got 2 different responses. So it's very difficult then for the lenders to start taking views. And then I think ultimately is, you know, also the bank and the partner that you choose, because again, all these markets are quite different. I think it's very presumptuous to put all of them in one bucket. And I think in that regard, you know, select an advisor, a financial advisor that has some experience in that particular market, has actually done deals in that market, understand the issues. If it needs to make a phone call to a minister or central bank governor to, you know, solve the problem of the license for the funds to come in, it can help you with that. And obviously the bank as well. You know, I'm not trying to publicize my own bank, but I think it's important that that experience is there.
So just a few words. I think we're saying, I think it is important that all of us, all the stakeholders, are building trust and communicate between each other to make sure that we achieve one goal, which is closing deals. It's all good to talk about what we're going to close. If we don't reach financial close, there is nothing, no power coming into the equation. Now, the macroeconomic situation is changing across the continent, so we need to keep, and I think the panel has said a few times, but we need to keep 2 things in mind. The first one is the currency risk. A lot of countries, you know, I will sign PPA contract in dollars, but their customers are charging local currency. This is not necessarily sustainable. So I think we just need to be all mindful of that, trying to find ways to go around that. And the second one is, when we look at the continent, what we've seen across the last 5 years is a deterioration of the creditworthiness of the main utilities across. And I think the government have not been focused enough onto that. At one stage, if you don't have, you know, I will just quote one of my neighbors on the table. They say, you know, the power sector value chain, it needs to be sustainable. At one stage, if the customer cannot pay, if the private sector, which is invested in DisCo, cannot recover the tariff, you know, something is not going to be well in the sectors. And you can have the best contract you want. At one stage, this will explode. Thank you.
Doing business in Africa. You can't afford to be without Africa Investor.